Welcome to a new episode of Startup Mavericks, the good, the bad, and the lessons. In this podcast, we invite startups and coaches to talk about specific topics. And today, I'm more than happy to host Ludwig, our legal expert, especially for all things related to patents. Welcome, Ludwig.
Thank you for having me. Hi.
Yeah, I guess most of the time it's about trying to find a unique selling point and trying to conserve it, sort of, right? Making sure that people pay money and that on the other hand they have something protected. I guess this is how to sum up what you're doing on a daily basis.
Yeah, that's pretty much it. You protect the core idea of a product, technical wise with a patent, or you protect the coolness of a startup when you protect the brand with a trademark, for example.
Would you say that this is a really effective way how to create a unique selling point? Or should the product be better than just a piece of paper where it says, congratulations, it's unique?
Well, if I'd be naughty, I'd say ask Apple. But
why?
Because obviously the brand is very important with Apple. And sometimes, I guess, and that's not for Apple, it's not Apple bashing. Sometimes the brand and the value the brand conveys is more than you really get. So if you buy a very expensive handbag, then you might be better off with a better quality from somebody that does it locally. Mm-hmm. But it's a brand. Mm-hmm. So yeah, I would say that the brand is very important, but you should have the products that match the level of sophistication.
Yeah, so it's not just, hey, I'm founding a startup and at the same time I think my product is so unique and I will protect it and I will be safe for the rest of my life, right? I guess that's not at all what it is about when leading a startup or having a specific product, right?
No, I guess that holds true for every company. You have to constantly evolve. You have to get new ideas, and when you have those new ideas, then you probably should seek protection, either for technical stuff, if it's applicable, with a patent, or if you have a new name, a new line of products, a cool logo, whatever it is. And then you go for a trademark or maybe a design if it's only the looks, or what, not only, but if it's the looks of your product, then you go for the same protection. It's not IP is not a field in itself that you should do because you do IP for the startups or for every company. It's just a tool in your toolbox. So when you're in the production industry, you have your lathe, your milling machine, whatever, and a patent, a trademark, and the design is nothing else. It's intangible, but it adds to the success of your company in terms of how successful can you operate on the market.
You are supporting a lot of different startups, not only from our accelerator, but of course from other institutions, startups and companies, of course, in general. When would you say is the perfect time to protect a brand, an idea? Yeah, so you have experience with, of course, different stages. Is there any particular answer that you can give there?
The general answer would be as soon as possible, of course. Mm-hmm. As soon as possible, but then I would differentiate when you're ready, when it's good enough. So especially as a startup, you have to allocate your funds like specifically and very targeted. So you don't do a trademark application for every name that crosses your mind and mm-hmm. every product line you might have or might not have or have for 3 months or something. Mm-hmm. So as early as possible, but only when the idea has a certain grade of maturity, so that you know, okay, this is gonna carry, and then also pick the most important, because in the beginning for every startup you're very short on funds, and IP is expensive in itself, so you should really pick the best bet. And the other way around. I mean, in the beginning, startups usually don't have a big need for a big portfolio. If you're a hardware startup, then probably you have the need for one patent or two, maybe. In general, every startup has a name, and most of the startups have a logo. So the name is usually the case for the trademark, and this should be done properly. You already can ask the question if you can push the logo a bit further down the road and use the money when you got funding, for example, or your first finance round. And then the big elephant in the room: how do you apply for a patent early on when you don't have money? So this is, and it's difficult. So unfortunately I have no model answer to that, and no hidden treasure where startups can get the funding from, because it's just expensive. It is expensive.
But generally we can summarize product before patent. So it should have a certain development stage.
Yes.
Not just the idea.
If your idea, there goes the typical attorney answer. That depends. If your idea has a certain degree of maturity, so you're sure about it, you can go for a patent. You don't have to have the finished product. Most of the time, it's even with big industry clients, they have the idea and then they develop the specific product to it. So I would say if you have an idea and it's well boxed in and well differentiated from other ideas, and you have a nice package, then you can and should go for a patent. And the golden rule is keep your mouth shut until the application is filed. So bring NDAs in places with persons or institutions, companies you cannot control. And if you want to go live, present your product, then you should really have your application in place, and then you're free to present everything you want. But the biggest mistake you could do is show the product and then get the feedback that's a great product, and then find out you should have done a patent on it.
But a common mistake then is that people publish, for example, their ideas sort of in a blog post, or
that's very common.
I don't know, they present it more or less on a public event, and this is one of the biggest mistakes they can do if it's not yet confirmed as a patent, right?
Patent application, you don't have a granted patent, because getting a patent granted takes years. I mean, we're looking easy 3 years from the day of application, easily. So,
but when would be then the first time that I'm allowed to?
When the day you drop it at the, figuratively speaking, in the letterbox of the patent office, then you're allowed to talk about it. So if a startup has a huge presentation, a pitch, whatever, on a day, then this very day is the last chance to file the patent.
Okay, understood.
Without having problems that you created your own prior art that gonna hunt you.
And there are, as far as I know, two major differences in patents: the design one and the, how do you say, utility patent. Is this correct?
If we talk in China, you're totally right. No, you have three different kinds of protection rights. You have trademarks, which can have almost any form. Then you have the technical.
So that's a logo, for example.
That's a logo. That can be a sound. That can be your color, your name, like the word itself, then the word in a specific design. I said a sound. It can be a movement. They even try to get Ascent as a trademark, but that's not possible yet. Probably it will come, but it's not possible yet. So that's trademarks. And then you have everything that is technical. This is the let's call it the normal patent, like the 20-year valid patent as you know it. And then you have the utility model. That's what you mentioned. It's always said it's the smaller brother, but basically it's an equal brother. It has a smaller shelf life. You have 10 years maximum protection, but it's easier to get. You don't have a substantial examination. You file the application and it enters the registry without substantive examination. And then you have the design, and this is a separate protection right that protects the looks of a product or a graphical user interface or a design of a fabric, for example. And this is totally independent of the technical feature. So if your computer looks like your vase, then they would be infringing.
People also often ask the question, is it possible to protect code from web developers somehow?
The code itself, the very code is protected by copyright law. But it's very specific and it's not very broad, this protection. If you're asking for software patents, this is against common opinion. This is very possible. We could easily talk about 3 hours alone about software patents, but the current state is if your software has an influence on the real world, so outside your computer, a sensor, I don't know, it controls a 3D printer to print better, whatever it is, like influence on the real world outside the computer, then you can have it. For the time being, it is not possible to get European protection and also German on a software itself, like simulation software is a good example. So if you have a simulation software that only does simulations, currently you cannot have protection, or it is super difficult to get protection on it. I think that's not correct, and I think the pendulum gonna swing in the other direction, because you certainly have inventions and development in that field, pure software, and but for the time being, it's very difficult to get a patent only on pure software without influence in the real world outside the computer.
I've heard about this hack that you should print out the code, put it in a letter, and send it to yourself. And don't open the letter.
This is how you can prove that you had the code at a certain point in time. You can do that. But there's companies on the internet that provide you with a timestamp for such copyright issues. But and this is very important. I had quite a few cases where those deposits of a copyright were confused with a proper patent application or something. So it's not the case. If you bring something public without having a patent application on it, you created prior art yourself, and then you probably killed your own patent. So those companies, they provide a good service if you want to prove a certain prior art at a given moment in time, and want to have that proof done quite well and quite airtight, then you can do that. It's not gonna help you in the sense of getting a patent or something. It's just a proof that you had what you ever have deposited.
Okay, understood. Before we talk about like how much do specific types maybe cost, at least from, I would say, maybe from a figure perspective, is it like 500,000, 50,000, 100,000 euros for a specific kind of patent? And of course, also the startup mistakes or cases that you know. We have a special section in this podcast that is called Either Or. So I'm going to give you I have here 5 questions with me, and they're always 2 perspectives, or let's say an either or question, and I would just like you to directly choose one. We can discuss it, of course, afterwards. Yeah?
Okay, sure.
All right, are you ready?
Yeah, sure.
Good. Number 1, financial or legal security first in a company?
Legal security.
Interesting. National patent first or directly going international?
National patent first.
Okay, we're going to talk about that one. Working in a small or a big legal company? For all those people who listen, maybe who want to do something similar like you.
Small company, of course.
Utility patent or just a design patent? Can you choose sort of?
No, they are
so different.
They're very different. It's like apples and bananas.
Yeah, so it's like both. Maybe we can let it
go.
Yeah.
In that case, I would say both, of course.
And working with startups or companies, in that sense of bigger companies.
Startups.
Okay, interesting. Thank you for that. So I guess what we learned already is in terms of the different patents that there are so many different ones that I guess really often a combination makes sense.
It is. You in the corporate world, like the big companies, your product has a name that can be protected by a trademark. It usually is designed in a very specific way, even if it's a technical product. Then you can apply design on the looks, and then of course you have technology within, and that can be protected with a patent. Usually, is a lot more patents than only one per product. Like on the window wiper, I read that there is 80 to 120 patents only on the window wiper. So.
Okay, but still, you said national patent first instead of directly going international. Why?
Because it's cheaper. No, there's especially for startups. There's a cheap way, or a cheaper way to get an international application when you file nationally first. So it's going international via a national first application. And
can you then maybe give us an insight about the costs? So what is the difference between, for example, the national patent and the international one? Do I need to have 5K in the very beginning, and if I would like to have a European-wide one, it's like, I don't know, 50K, and then worldwide 100K? Is there a sort of number that you can?
I can give you relations. So whenever you're national, so German patent, German trademark, everything that is within the country is fairly inexpensive when it comes to office fees. Usually, when you do the work yourself, and you perfectly can do that, you can if you can, then the office fees in Germany are very reasonable. When you go European, either the trademark, the design, or the patent, you step up the ladder quite a bit. So you can add a 0 at least.
From 5 to 50, sort of?
So yeah, you're definitely going to be, like, for a European patent, when all is said and done, you're in the 5-figure range.
Okay.
So not the upper one, but 10 to 20 is, that's reasonable. Yeah. And then when it goes internationally, you really don't have any boundary, because also it depends where you go, because there's no international application in the sense that you file one application and then you get the whole world. You still have to choose the countries, and the more you choose, the more expensive it gets. So and it gets expensive pretty quickly. The problem here is that in most of the countries you need another patent attorney that is a local, so you're already paying 2 patent attorneys. And you can imagine if you have 10 of those countries, it's expensive. And then you have 10 separate granting proceedings. So if you really want to go internationally, that's a whole another ball game when it comes to costs.
What were the highest costs that you ever had to deal with?
I had my most important proceeding so far was a 6-figure proceeding regarding a Chinese trademark, or a trademark that got hijacked in China, and we fought for getting it back, and we got it back, but it was extremely expensive.
But that's maybe also an important point here. You always need to fight for your own patents, right? It's not somebody else fighting it for you.
Yes, that's a good point. That's exactly the thing. Nobody will care. Like the government, or no government.
Nobody will tell you.
Not even. No, not even. You in Germany, you can even go along and apply for Coca-Cola as a trademark. They will enter that into the registry, most possibly, because there's no checks for all the trademarks from the office. In Europe, it's a bit different. They don't check for all the trademarks. However, they at least inform possible all the trademark owners that there could be a problem. So it's a bit better. In the US, you have an ex officio checking for all the trademarks, and China as well. So it's different kinds of systems. But also for patent, that holds true. You have to find the infringer and to do your work. There's mechanisms in place that when you start the proceeding, then everything is there. But you have to initiate. Nobody will do that for you.
Did you ever experience the fight startup corporate?
No, not yet. To be honest, everything I was involved in quite a few, but that was at a very early stage, and we could sort that quite friendly.
What does it mean?
So it was some sort of trade. Usually it's silly things. So you unwillingly infringe a trademark, then you look after that, and you come to a conclusion or an agreement or something. I had one startup that had a problem with a big company regarding patents, but that was also resolved without going to trial. So yeah, I've experienced it, but not the commonly known stories. David against Goliath.
Okay, that's good. But can you maybe give us an example of a story where a startup did a big mistake? I don't know, spending way too much money or making mistakes whatsoever. Something that comes
think
to
there was quite a famous one. This company WeWork that provide shared office space.
Yes.
The founder had registered the trademark rights not to the company but to his name, which I usually recommend because it's then not so it's more difficult to get kicked out of his own company. In that case, it was exactly like that. He should be kicked out, and then he sold the name rights for another quite high sum. So it was a mistake of the startup, but not of the founder. So
I think it was. It
was in the millions.
100%. I think even he became billionaire by selling his company. Also, they wanted to throw him out. But he, with his name rights, etc.
Exactly.
He also
it was quite well played.
Yeah, I think even the term "failing up" was back then really
famous. Something like that. So it was a mistake of the company, but not his mistake as a founder. Certainly not.
And from the startup perspective, fails. Have you experienced some where you said, "I'm so sorry that this happened"?
Early on, it was. It's usually trademarks. This is the huge problem. It's not the awareness that most of the information is publicly available. So if you pick a name for your startup, you can check the databases that are publicly there, and then if you find lots of hits for your name, it's probably not a good idea. But that happens a lot, and the problem is if you have to do a conversion because you really have a bad trademark infringement of a bigger company, and you don't come to terms with them, then it's potentially the end of the startups. Yeah. Because if you're already in full sprint and you have to rename your company, that usually is not a good thing. This is what I experienced. Yeah, it's usually it's not trade. It's not patent cases or not patent related. Very rarely. It's
lower level even. Than
but the most part is trademarks.
I know a story about a startup that also chose a name that was taken already. They were selling their drinks. It was about drinks. And then they got approached by saying, hey, we have this name already. I'm not sure whether, it must have been a trademark. And then they needed to relabel everything. And it cost them so much money because they wanted 20,000 euros instead, like going to court and et cetera, et cetera. And they said, okay, so it will be less money and effort, although it was still a lot to rebrand.
Yes, and this is unfortunately it's very common. There was a client of mine had the same problem. They already printed the carton boxes, and then we had a look in the database, and there was the same exact trademark was already trademarked for the very product they wanted to sell in said carton boxes. So old bag and new name, new carton boxes.
So we had like a different kind of patent, trademark, etc. We just talked about, let's say, 5K, 10K, 20K. What is the cheapest alternative if I want to protect something? It's the design, right?
If you want to protect the looks, then it's the design. If you want to protect technical aspects, then it's certainly the utility model, because there's no substantial examination.
So what's the cheapest version to protect, and how much should I expect to pay?
There goes the typical answer again. That depends.
Logo, name.
It's really difficult to say. So if you want to go for a national trademark application, which you can do yourself as a startup, it is possible. You have to dig into it, but then you don't have to pay a lawyer, and the outcome is usually okay. It's not perfect, but it's okay. And you have something to present, and you have your name protected, and can show something to potential investors. It's fairly cheap. It's, I think, in the range of 300 euros for a trademark application, and you have a decent protection with it within Germany. The cheapest comparable in Europe would be already 1,050 euros in office fees. So you can do that yourself. Honestly, please, dear startups, please do not draft your patent applications yourself. It does not work.
I guess that's like a perfect last word towards this podcast episode. Thank you so much, Ludwig, for being our guest here, and for giving so many hints, lessons about the legal side of patents, etc. Thank you so much.
Thank you for having me. Great fun.
Ciao.
Ciao.